And then we'll get to the sovereign citizen that sued for, get this now, $7 billion. I've got the complaint, got to show it to you. $7 billion, Mrs. Powers. A lot of money. Unfortunately for her, the case got dismissed. So the first thing I want to do is torment you with useless words, because that's just how I am. You know, I get paid to talk, speak, and persuade for a living. Some people have said that I'm a master debater. I counter by saying that I'm a cunning linguist. Let's take a look at these words and you tell me. It's an adjective, good for it. Means very good and very fine. Ilogo fusio u hippo cunario. Whatever the hell it is. Elogo fusio u hippo cunarius. So after making love, the wife turned to her husband and said, "You were so elo go fusio hippo cunarius." Well, I think you deserve that. So here she is again, living the life. Here it is. She's suing the FBI. That typically is a bold move. So this is the Federal Bureau of Investigation, and then two agents. Oh, et al. Okay, well, it's spelled wrong. All right. Complaint and request for injunction. Okay, again, this is a pro per form where you're supposed to fill in blanks because they figure you don't know anything, and that's okay. And here's the $75,000 minimum for diversity, which means the plaintiff and defendants are from different states and does not involve a federal question. See, the feds are trying to avoid being an alternative forum for state court. Then she uses these other jurisdictional reasons. This has to do, if I remember correctly, dissuading a witness. I don't know. She's not worth looking this stuff up anyway, but okay. And here it is. The amount in controversy, missing the dollar sign, $7 billion. I don't know. Is my imitation of Dr. Evil okay? I mean, I'm doing the best I can, guys. $7 billion for compensatory and punitive damages. You don't set it up that way. For a conspiracy. Now, remember I told you, conspiracy is not a cause of action. It is a doctrine to attach liability to other wrongdoers. Under color of law, oh, that is a famous sovereign citizen term, under color of law. Of course, the term sovereign citizen makes no sense, because if you're a sovereign, then you're not a citizen. And if you're a citizen, you're not sovereign. But hey, that's the term they use. That's the term they get. Financial loss, including but not limited to homelessness, loss of nearly all personal belongings. Now, remember, we don't know what those belongings are, but they must be quite valuable to want. $7 billion, loss of vehicle resulting in loss of work, etc. See, etceteras are bad in complaints because it's supposed to be under Rule 8, a short, plain statement, and you're supposed to reasonably apprise the other side of what it is you're really bitching about. Loss of parental consortium, damage to reputation, undue physical injury, an undue injury, kind of an unusual way of saying it. Undue irreparable mental and emotional harm, and unlawful arrest, excessive use of force, violations. This one's an interesting rights not already reserved by the Constitution that delegated to the state. She's suing under that. We'll have to see how this one goes, but then we already know how it went. She lost, thrown out. Now, notice that it says attach, like additional sheets when necessary. What are the facts? So this is a factual thing, not a conclusory allegation thing. The FBI acted on a false allegation. We don't know what that is. That's all conclusory. Using a void and fully vacated fraudulent court order. That's all conclusory. And when I say conclusory, what I mean is there's no real facts here. A conclusory allegation is just a conclusory statement. Conclusory allegations do not count in terms of a well-pled complaint. In California, for the state court, that would be Blank versus Kirwan. In federal court, there's Twombly and all the others that we all know. We just automatically just put them down because everyone knows what they are. And the Ashcroft decision. So this doesn't point to the specific court order. It doesn't give us a judicial determination as to why it was voided. She would then have to overcome judicial estoppel, because once she says that a state court action was involved, then by definition, federal courts respect state court judgments, judicial estoppel. Also, it may be that you're relitigating the same issues again, and they would be barred for collateral estoppel and res judicata, depending on what actually is being alleged. So, you know, did no due diligence to verify any of the information, hunted the plaintiff down like a criminal, and then when she told him she did not consent, that, you know, if we're playing sovereign citizen bingo, we're starting to line up the shots now. I do not consent. You hear that many times. It doesn't help sometimes. Used unnecessary force. Unnecessary versus excessive. Got to be careful with the word choices here. And this is all conclusory, just run-on sentence. It doesn't tell you anything. To falsely arrest her. Okay, well, that's another conclusion. And did tackle and brutalize her. Brutalize. Be nice to say exactly what happened while ripping them from her arms, traumatizing her. So let's talk about the semantics of this. Did arrest her and did tackle and brutalize her in front of her children while ripping them from her arms, traumatizing them. So so the children were ripped from her arms before she hit the ground, before she was tackled. You gotta be careful how you plead these things. Unlawfully seized her children. Well, that would be something without just cause. Well, if you said it was unlawful, then there would be no reason to say that there is no cause. It was just tantamount to kidnapping, legal conclusion, not a factual allegation, and the plaintiff has not seen or heard from her children since that day. The FIA has made comments that showed clear bias against the plaintiff, willfully disregarded the facts and evidence. This is all conclusory. These are just conclusions that don't mean anything, ripe for a Rule 12b-6, and further asserted that she was targeted because of her religious philosophical beliefs, and that she was exercising First Amendment rights on Twitter and Facebook. More of the same crap. Horseshit complaint. Make sure when you spell that you use spell check. Capital P's in the middle of a sentence sometimes may warrant attention. She doesn't have the authority to bring criminal charges herself. So that goes nowhere, probably would result in a motion to strike. Federal Rule Civil Procedure 11 is what pattern California's Code of Civil Procedure Section 128.7, which I just used with devastating effect against a dipshit attorney in Orange County. The dipshit attorney pissed me off with a multi-million-dollar suit, so I filed a motion against her and make her liable. And I said, this lawsuit's bullshit, dismiss the case. I'm not dismissing this case. Great. I'm going to put your money where your moral mouth is. We'll see how much you believe in the case when I name you in a sanctions motion to dismiss it because it's legally frivolous under CCP 128.7. Here is 128.7. I threw it at this attorney and she quickly ran for the hills and dismissed the case because she didn't want to pay out of her pocket. To her, that was too much to risk. Now remember, there's procedural, administrative grounds, and then there's substantive grounds. Substantive dismissal would be on the merits, whether through a Rule 56 motion for summary judgment, anything like that. But an administrative dismissal is because you didn't comply with the rules. And here, if you're going to proceed as your own lawyer, when you're not an attorney, obviously, then you got to comply with all their rules and pay the filing fees. And if you don't, they will just boot the case, I think, under Rule 41. Yeah, here it is, 41, failure to prosecute. So the case went nowhere. And I could see why the judge got tired of her very quickly because she's using the fill-in-the-blank federal forms to assert run-of-the-mill, bullshit, frivolous lawsuits. Have a good day, and I'll see you when I can, but I'll be tied up with a trial soon.
This is an unusual word, bibliophobia, a noun. Phobia, of course, means fear, and the Greek word phobia, and in bibli, which means books. A person who strongly dislikes books. Now I'm going to use it in an incorrect way. Quote, my baby refuses to wear his bib. I think he's suffering from bibliophobia. Or, a writer refused to cite to his sources of material, and his refusal to include a bibliography is likely due to bibliophobia. Scrupulous is one of my favorite words, an adjective, sick from excessive indulgence in liquor, intemperance in eating and drinking. Quote, used properly. After drinking 4 bottles of Jack Daniels and eating 5 dozen eggs in one sitting, Isaiah experienced massive crapulous and then ran to the toilet. Farlick's another new word that I discovered. It's when a sprinter or runner is changing speeds from running to sprinting. So I use it in a sentence, correctly, I might add. That runner began to fartlek halfway through the race at an increasing rate. The other runners behind him were all affected, quit the race, and treated for nausea. Well, here's a word that can get you in trouble real quick, and the word is masticate. It's a verb. It's the act of chewing on food. And so I use it in a sentence improperly to throw the connotation off. Quote, "We told that man that he cannot eat food in this area, and he responded by openly masticating in front of everyone." Another very strange word that can go with masticate is absquatulate, another verb. The ATE is the action, that's what makes it a verb. It's leaving suddenly. Once that man stopped masculating, he suddenly I'm going to try that again. Once that man stopped masticating, he suddenly absquatulated. Hey, I'm not going to be able to do this, guys. I'm going to try this again. Once that man stopped masticating, he suddenly absquatulated. It was so vile and rude.